Well, let me predicate the question to Sebastian on your response. Mr. Hon, if you can hear us, doesn't it go against the principle, because I mean we thought that there are principles, universal principles at that, of an agreement, which I mean when you say that it's voidable, I mean yes, if the other party can go to court if it discovers something new in that matter. So if we predicate this argument to some extent on that and listen to what Mr. Falana has said, he says there's no question on the fact that we can appeal this, even if it's a day within that window. The question of bad faith doesn't arise.
Now, I've heard what my brother said, Femi Falana has said. I respect him so much. But I still maintain a different position, with due respect. Now, let me put it in this perspective. I would be glad if Bakassi comes back to Nigeria. But I am just being honest and objective. Now, in international law and even in local law, we have what we call estoppel by conduct. Even if the British government has written a document saying this territory belongs to Nigeria, and subsequent to that, Nigeria went to enter into an agreement with Cameroon, ceding that territory, that agreement supersedes what the British government said. We're talking about the Nigerian government being bound by an international contract. Recently, the case between Attorney General of Akwa Ibom State and Attorney General of Rivers State, where the Supreme Court ceded 70 wells that formerly were reckoned to belong to Akwa Ibom State, it was based on an agreement and also on the doctrine of estoppel by conduct, also called estoppel impasse. So now, even if the British colonial masters had written a document claiming that the territory belongs to Nigeria, we have ceded that, we have set aside that document and entered into a voluntary agreement. We cannot now be heard to say that, no, we want to go and rely on a document written before the agreement. And again, I also heard my brother mention that, yes, the Falana matter decided that the Constitution is supreme in the hierarchy of legislation. We are now still restricting ourselves to domestic law. In international law, international public law, a treaty voluntarily entered into between countries or among countries ranks superior to domestic law. That is settled case. That is a settled case in international law. So I mean as much, and again, another point which I want us to accept is that even the proponents, including my little brother Femi Falana, are admitting that the legal team did not perform well, that there were some fundamental mistakes. So are we not addressing our minds to the fact that those things would have gone to destroy our chances to appear? So let us be objective with due respect.
Okay, could you respond to this before you go then? Just a moment.
Under
what circumstance?
Bakassi to belong to Nigeria. But if we are admitting that there are some fundamental mistakes,
okay,
admitting that we ceded this territory to Cameroon by an international agreement. So I see no reason we will be insisting.
All right, just a minute before you leave. Under what circumstances can we ask for a review? Under what circumstances can we tender these new facts that have emerged if you say that international public law supersedes our local laws?
No, you see, just like in local judicial proceedings, a judgment of a court is set aside on many grounds: fraud, misrepresentation, and other mistakes committed by the adjudicating tribunal. Now, but this fraud or misrepresentation must not have been done by the party that is applying for the review. It must have been done by the opposite party. So we cannot now use our own inefficiency, quote unquote, I'm not submitting on that yet, to say that, okay, review panel, look at when we came, we made some fundamental mistakes, why can't you look this way? No, the law doesn't work like that.
What if we predicate our response not on the documents that earlier presented, but on the matter that fresh facts have evolved, have emerged by the other party, what they've done wrong? Wouldn't that be a ground of appeal? I mean, of review?
No, let me hear you well. Sorry, I didn't get you.
If we present documents or we present facts that the other party, in this case Cameroon, must have done something which contravene or something which warrants, which we interpret to deem as fresh facts upon which we can ask for a review. If that were the case, would that qualify us for a review?
From all the arguments I have been, from the arguments I've been listening to, nobody is alleging that Cameroon suppressed evidence or Cameroon practiced fraud or misrepresentation laws. We keep on saying that our legal team was not efficient, that our government made a mistake, this and that. We cannot transfer our mistake into an advantage. It's not possible. It's not practicable. It's not legal, with due respect.
What of the fact that people are, some lawyers are saying that Cameroon has not exactly abided by the terms of the Green Tree Agreement?
In what respect?
They haven't abided by the terms of the Green Tree Agreement. The residents or those who live in Bakassi have been complaining that Cameroon hasn't abided by the terms of the Green Tree Agreement. Can't we go to court, or can't we base our appeal based on that particular fact?
Yes, it cannot be by way of an appeal. We say, okay, the Green Tree Agreement, I think of 1973, Cameroon, you have not kept to the terms. There is a judgment now based on that agreement. So, the International Court of Justice, look at this again. Cameroon is breaching the rights of the Nigerians who are there in spite of your judgment. It cannot be by way of review or appeal. Okay. It is a consequential proceeding.
All right.
Based on that judgment.
Okay. Thank you very much indeed, Sebastian On, Senior Advocate of Nigeria, for your thoughts on this matter. Well, coming back to this one now, well, he says that for the arguments he's heard, he hasn't heard anyone say that, well, yes, Cameroon has done so and so, upon which we predicate our review. Our review. But what he's heard is that, look, we made a mistake in presenting documents, and if that were the case, we don't have a grounds for review.
Well, before that, let me just say this about the Green Tree Agreement.
Okay.
The Green Tree Agreement was signed in 2006 between the President of Nigeria and the President of Cameroon, supervised by the Secretary General of the United Nations. And the beauty of that agreement is that it is stipulated in Clause 3 that Cameroon shall recognize the nationality and respect the nationality of the people, the Nigerian people in that territory. Secondly, their culture, their agricultural and fishing rights shall be respected in that territory. They shall not be armed or intimidated by Cameroon. Levies will not be imposed on them, or taxes by Cameroon. All these provisions have been violated by Cameroon. But we can't go to the International Court of Justice for that. We have to go back to the United Nations. The agreement is supervised and witnessed by the United States government, the government of Germany, Britain, and France. That agreement is now being violated by Cameroon. Can you ask the United Nations to set up a team to monitor the implementation of the agreement? We can do that, right? But with respect to the resolution of the Senate and the position of the Nigerian Bar Association, at any time that you come across fresh evidence, and in this case, the agreement, the Treaty of 1811, was not signed by Nigeria. I mean, the Republic of Nigeria. That was by the colonial regime.